does not pose a great risk to the community,
Él no representa un gran riesgo a la comunidad.
that I'm constitutionally compelled to release him on his own recognizance.
Y constitucionalmente yo tengo el deber de dejarlo en libertad bajo palabra.
Sir, you need to make sure you show up for court on October 23rd at 9 a.m. at the Reno Justice Court.
Señor, usted tiene que asegurarse de presentarse a la corte, a su audiencia, en la Corte de Justicia de Reno el 23 de octubre a las 9 de la mañana.
If you don't, you
Yes.
will start scoring high risk.
Si no lo hace, entonces usted va a empezar a tener un puntaje alto de alto riesgo
And I'll be forced to set a bail that you cannot make.
y entonces me voy a ver forzado a imponer una fianza que usted no podría pagar.
Thank you.
Gracias.
Judge, are we addressing the warrant today, or was he ordered on the warrant on the Pratt because I was confused. We were confused. That's why we sent him back. We weren't sure what the.
Yeah, warrant only.
Su señoría,
Okay. Sorry.
ya, su señoría, estoy un poco confundido. Estamos hablando, vamos a hablar el día de hoy sobre la orden de arresto o qué pasó con la orden de arresto, porque parece que por eso lo habían mandado y no sé qué dijo el policía ahí. So I don't know what the policeman said over there, but then you said okay.
Are we good?
Yeah, I think so.
¿Estamos bien?
Thank you.
Okay.
Constantine
Eso
and then Vargas. I think that's all the interpreter matters we have. Thank you, Ms. Interpreter.
Oh, so we have 3, Your Honor?
Yeah, one we continued, I believe, for victim notification.
Oh, that's true. Oh my gosh, I'm so sorry. Thank you so much. Have a good day. We'll see you tomorrow.
Bye-bye. Thank you so much for being here.
Of course, thank you.
Constantine and then Vargas.
Your Honor, Mr. Constantine is going to waive he's not here, right? Yeah, we're going to waive his appearance. He's a fugitive from another state. We can go forward on the bail in his absence.
All right, what does the state feel is appropriate?
Thank you, Your Honor. So Mr. Constantine scores a 9 on the risk assessment with 1 point for felony convictions, 1 point for misdemeanor convictions, 2 points for substance abuse. As Mr. Foos just noted, he was also arrested on a fugitive warrant. He's been in Reno, he says, for 2 days. He's a California resident. He has a very lengthy criminal history. It's all from California. It's 56 cycles. 2025 alone, he's got a felony arrest for felon in possession of a firearm, parole violation, another arrest for a parole violation, felony conviction for burglary. He was sentenced to 16 months prison. I guess by California math, he's already out. Looks like he was arrested on a garden variety of other crimes as well. Some might be convictions, but it's very hard to tell from the criminal history. It's very confusing. He had a bench warrant also this year for failure to appear on a felony. 2023's got felony convictions for PSMV and acquire ID with intent to defraud. So similar to what we've got here. Felony conviction in 2022 for evading, similar to what we've got here. Another evading felony conviction in 2021. More felony convictions for felon in possession of a firearm, PSMV, use credit card of another in 2019. And it looks like 1, 2, 3, 4, 5 additional felony convictions that I counted between 2014 and 2017. So he is a very good candidate for habitual criminal adjudication. The state is requesting bail in the amount of $100,000, bondable only, DAS with testing if he posts, and GPS monitoring.
Mr. Bruce?
Nothing to add.
Bail be set as requested. Next court date will be the 24th at 9 a.m. Vargas and then Johnson.
I mean, I told him, put it like that.
I'm sorry, Your Honor, which name did you call?
Vargas, and then on deck will be Johnson. All right, what's the state feels appropriate on this matter?
Your Honor, the state's requesting bail in the amount of $5,000, DAS with testing for controlled substances, no contact with the victim as a condition and pursuant to statute, and no firearms. We were able to get in touch with the named victim. She won't be attending the bail hearing, does want a no contact order. She estimates that over the course of their 6 years together, he's been physically violent toward her on 20 to 30 prior occasions, but this is the first time she's reported. Our investigator noted, I could tell this was a major step forward for her in reporting the defendant. So he scores a 6 on the risk assessment. He's got a felony conviction in 2019. for sales of a controlled substance. Looks like he did adult drug court in that case, but was removed in 2020. And then he was honorably discharged from probation in 2024. 2019, he's got a misdemeanor conviction for DUI out of this court. He was released on his own recognizance, and then his own recognizance was revoked when he committed that drug sales offense. So, as I mentioned, there's continued violence with this victim. She is afraid for her safety. And for those reasons, I think he is a risk of safety to the community, specifically to this victim. So I am requesting bail in the amount of $5,000, DAS with testing for controlled substances, no contact with the victim as a condition and pursuant to statute, and no firearms.
All right, Mr. Foos.
We'd ask the court to consider an own recognizance release with the addition of GPS house arrest monitoring for this gentleman so that we can make sure that he's abiding by the no contact order. I think he has some history of being able to comply with court orders, being able to successfully complete probation. So I think that he could be released on his own recognizance with the no contact order with house arrest GPS monitoring.
When did he get out of prison?
I never went to prison.
He completed probation successfully.
When?
2024 was when he was honorably discharged, Your Honor.
I believe it was a 2018 case. Is that correct?
19.
2019 case.
Case. Yeah, I see the case. Again, I'm concerned about our ability to effectively monitor the defendant, but he scores a moderate. There was a bill this year by the governor to require on these cases proof that the defendant did not possess firearms. That's possible with DAS. They can go in and make sure there's no firearms in the home. That's not possible with pretrial services. It's going to cause an issue going forward in some of these cases, but he scores a moderate. Now, I'll just say if this was a high risk, I would not be able to find that there's sufficient means to mitigate that risk, given that pretrial service is going to be the only option available to the court to supervise these individuals. And it's just not effective for high risk individuals. But he scores a low moderate. And therefore, while the state makes good arguments, I'm constitutionally compelled to release him on his own recognizance. Again, I have no idea who's going to be supervising or what the ability to supervise is. So the only conditions will be no contact pursuant to statute for the maximum period of time. And no contact is the condition of this case. No possession of firearms. I have no ability to enforce that. And without DAS. And his next court date will be an out of custody arraignment date that I'll set for Monday, the 27th at 9 a.m. We'll see you then.
9 a.m. Judge.
Yes.
Thank you.
Thank you, Your Honor.
I'm not Your Honor.
Judge, that's all. Thanks.
Well, I think you're an honorable person, Mr. Foos.
Well, thank you, Judge.
Johnson and then Avampado. What does the state feel is appropriate on this matter?
So, Your Honor, the state's requesting bail in the amount of $10,000 for Mr. Johnson, DAS supervision if he's able to post no contact with minors by any means, be that in person, by phone, online, or any other electronic means. So,
Hold on, Mr. Foos has something.
I'm sorry to interrupt. Can we just trail this one? I thought this was one of the.
Sure.
The last one, right?
Avampado and then Butler.
Okay.
Yeah. Okay.
Good morning, Your Honor.
Good morning. What does the state feels appropriate on this matter?
so Your Honor, I'm requesting to continue one day for victim contact. We did reach out to him and are waiting to hear back.
All right. We'll see you tomorrow, sir.
Thank you.
You're welcome. Butler and then Eddie.
Good morning.
Or Mr. Butler. What does the state feels appropriate on this matter?
Thank you, Your Honor. So again, the state's requesting a one-day continuance for victim contact.
All right, we'll see you tomorrow, sir.
Cool.
Eddie, and then Hopkins.
It's Edie, Honor.
Oh,
Your Honor.
sorry. Is that right?
Yeah, Edie.
All right. Good morning, Miss Edie. What does the state feel is appropriate on this matter?
So, Your Honor, the state's requesting bail in the amount of $5,000 DAS with testing for controlled substances if Miss Edie's able to post. She scores a 12 on the risk assessment with 2 points for failures to appear, 1 point for misdemeanor convictions, 2 points for having a pending case, 2 points for substance abuse. She was also arrested on a traffic failure to appear warrant out of Wadsworth. She's got a non-extraditable warrant out of Kansas. It looks like it's a pretty old warrant based on her criminal history. 2025, she's got a misdemeanor arrest already this year for failure to appear, a misdemeanor conviction for possession of drug paraphernalia. At the time she was arrested on that possession of drug paraphernalia charge, she was also booked on an other agency warrant. She got another misdemeanor arrest for failure to appear in 2024, a misdemeanor conviction in 2020 for possessed drug not for interstate commerce, another misdemeanor arrest for failure to appear in 2019, felony arrest back in 2002 for forgery and theft out of Kansas, and then a misdemeanor arrest for DUI out of Kansas. She's got a lot of older history out of California in the 90s and 2000s, including a number of arrests for actually possession of a stolen motor vehicle. So due to her very high risk of future non-appearance, high risk of continued criminal conduct, the state's requesting bail in the amount of $5,000 DAS with testing for controlled substances if she posts.
All right. Thank you, Mr. Foos.
You know, we'd ask the court to consider an own recognizance release. I recognize that she has a lot of failures to appear. I think the pending case, I don't know if it's considered the citation. I doubt it because it's no longer, I don't think it's criminal in nature. So it's probably the Kansas case, which appears to be from 2021. Is that correct? I think that's what the state said.
2022.
2002.
2002, so quite a long time ago. I don't know if Kansas even wants to bring her back. That being said, the quote knowledge that she should have had doesn't seem to comport with anything you normally see on a possession of a stolen motor vehicle, such as a punched out ignition, saying you bought the car that's worth $20,000 for $500 or $50. She indicated to the officer that she borrowed the car from her son's friend, who I think it turns out to be the boyfriend of the other person in the vehicle. But there's no indication in the police report that she knew or should have known the car was stolen at the time. So I don't believe that they can prove that. The PCS wasn't found on her. It was merely in the vehicle along with the co-defendant that was already OR'd. There was lots of other drugs and narcotics found in the vehicle in the trunk. Also, no indication that she knew or should have known that stuff was there. So based on that, I'm going to ask for an own recognizance release and check in with DAS.
All right. We have found probable cause for the defendant's detention with regards to those remaining issues. While they're appropriate under the statute, the likelihood of conviction to be considered, it is best to have an opportunity for the district attorney's office to meet with their witnesses and respond to those factual allegations with regards to the ability of the state to prove this case. That's not, what a probable cause declaration is intended to do, is properly set out all the facts and circumstances. She certainly is entitled to a preliminary examination in 15 days that we'll give her, so that she's not detained unlawfully if the state can't provide proof of this charge. The issue for me, the primary issue, is the risk she poses to the community to fail to appear and to reoffend. And unfortunately, it's high. Is there an ability to mitigate it? I think it's possible, absolutely, that if we had a caseworker assigned to her that helped her get into treatment, that's the right thing to do under these circumstances. But again, the county has not provided that option to me, resource-wise. So I don't have any viable options with regards to minimizing the high risk that the defendant poses, and therefore I have to find, by clear and convincing evidence, that bail is necessary to ensure the safety of the community and the appearance of the defendant. it'll be set as requested. We'll see you back on the 24th, ma'am. Thank you.
Can we see Johnson next?
Oh, okay, is that where we're at now? Okay, yeah, Mr. Johnson, I think we can take Mr. Johnson now.
Of course.
Sorry about that.
It's okay. What does the state feel?
Thank you, Your Honor. So I can't recall where I was. Anyway, so Mr. Johnson scores an 8 on the risk assessment. He has 1 point for violent criminal convictions and 1 point for misdemeanor convictions. He's got a 2018 misdemeanor conviction for reckless driving, reduced from a DUI, 2016 misdemeanor conviction for domestic battery first, and then a 2008 misdemeanor conviction for carrying a concealed weapon. So really the trouble for Mr. Johnson, and the trouble for, I think, the court in deciding to release him is that this type of crime, it really poses a high risk of danger to the community. I mean, when we look at this, we don't just look at the fact that this is was an undercover officer acting as a minor. We look at this really in the context of the broader sex trafficking underworld. And so with that said, the state's requesting bail in the amount of $10,000, DAS supervision if he posts, and no contact with minors in person, by phone, or online.
Mr. Foose, before I continue on this case, do you think your previous client would be interested in a release to either a sober living environment or treatment if it's appropriate?
I would have to discuss that with it. I'm not sure that the drugs, I know that there were throughout the car. I don't think they were hers. I didn't get into that. But I could go back and talk to her, and I could email the clerks and let them know if you want to address.
We set it on the docket for tomorrow and see if there's some way to minimize the risk that she poses to the community.
Thank you. I will go back and talk to her.
All right, and I'm going to set it on the docket for tomorrow for a bail hearing.
Okay.
Can I say something real quick?
No.
Hold on, we're not done with yours. Your attorney hasn't had a chance to start yet. I was just going back on the
Court's indulgence. Can I get a mute, please? What do you want? Yeah, I believe he scores a 8 on NPRA. I believe 4 of those points were for his personal information. I show that his prior history was for a DUI and a domestic battery and speeding tickets. So and we were able to confirm by speaking to his father, he works at Panasonic, lives in Cold Springs on Mama Bear Court, has a phone number. And so with all that confirmed, he'd be a 4. I'm going to ask the court to consider $10,000 bondable, house arrest, GPS monitoring, conditions of no contact with minors. If there was no money exchange in this, I think this would be possibly a legitimate contact between an adult and a 16-year-old, since the age of consent in Nevada is 16. And so the issue is really the attempt to solicit someone for sex, and we'll have to look in further as to who asked for the money and etc. But obviously this is not a real person. There's no history of this gentleman engaging in any behavior like this in the past. He can be supervised, I know he's an adult, but he does have family in town, and so would ask the court to consider $10,000 bondable, GPS monitoring, and no contact with minors under 18.
All right. So I think the reason I want the previous case, Miss Edie, back is to further examine her criminal history with regards to risks that it poses to the community. and ways to minimize that. In this case, I think it is, as the state's pointed out, quite different with regards to the risk to the community and the ability to minimize that risk. And therefore, I find by clear and convincing evidence the state's shown that bail is necessary to ensure the safety of the community. The appearance of the defendant will be set as requested, and the defendant's next court date will be the 24th of October at 9 a.m. Thank you, Mr. Johnson. Good luck to you. Leverett and then Neil.
I gotta go. Leverett? No, you can go back. Oh, got it. Leverett? Of course he doesn't. Your Honor, he's gonna waive. He has a PMP hold. We'll submit on the amount requested by the state.
All right, what is that amount?
State's requesting $1 million, Your Honor.
That'll be the order. Neil and then Singh. All right, what the state feels appropriate on this matter?
Thank you, Your Honor. So the state is requesting for Mr. Neal $75,000. I would request DAS with testing if he posts and no contact with minors. So Mr. Neal scores an 8 on the risk assessment with 1 point for felony gross misdemeanor convictions, 1 point for misdemeanor convictions, and 2 points for substance abuse. He's got felony arrest for a probation violation in 2023, petty larceny and felony probation violation arrest in 2022, another felony probation violation arrest in 2021, a felony arrest in 2020 for possession of stolen property and PCS. That was out of Douglas County with no disposition noted. He's got another felony arrest in 2020 for failure to appear after bail, another felony arrest same year for failure to appear after bail, 2019 misdemeanor conviction for possession of drug paraphernalia, felony arrest for fail to appear after bail, 2018 another felony arrest for fail to appear after bail, a felony arrest for violating conditions of release, felony arrest for PCS. It looks like he was removed from specialty court. That's a felony conviction, correction, for PCS. He was granted the opportunity at diversion in specialty court. His deferred status was revoked. He was granted probation, and then his probation was revoked in 2023 after absconding numerous times. And then in 2017, he's got a misdemeanor conviction for possession of drug paraphernalia. Mr. Neal doesn't show up when he's got a simple PCS hanging over his head. Now he's got numerous offenses relating to child sex crimes. And so the state's very concerned about his future appearance, but more importantly, the state's very concerned about the risk to the community. This defendant attempted to meet up with a 15-year-old for sexual activity, and he had drugs in his car, fentanyl and methamphetamine. So the state's requesting bail in the amount of $75,000 DAS with testing if he posts and no contact with minors.
All right, thank you, Mr. Foos.
Yeah, he scores an 8. 3 of those, take that back. 2 of those points were for job and phone. We contacted his mom. He lives with her in Sparks, been there his whole life, has confirmed his phone number, does confirm that he works at a property maintenance at, I think it's the River Apartments. So that would take him down to a 6, would ask the court to consider a bail of $25,000 bondable, no contact with minors, and GPS monitoring.
All right. I find by clear and convincing evidence there's no conditions that I can set to ensure the safety of the community and the appearance of the defendant. There is no effective way to prohibit this defendant from engaging in this behavior and in fact following through with it, especially with the county doing away with DAS. So the bail will be set as requested with the conditions set as requested. October 24th, the defendant's next court date. We'll see you back then. Singh and then Robinson.
Oh, good morning, Court.
Good morning. Was the state feels appropriate?
Your Honor, the state's requesting $50,000 bail for Mr. Singh, DAS if he posts and no contact with minors. So Mr. Singh scores a 5 on the risk assessment. He has no prior documented criminal history. However, it does look like he's got an immigration hold at this point. So that matters to the extent that it increases his risk of future non-appearance. If he's deported, he's not going to show up. But even without that, the state would be requesting bail for the reasons we discussed in Mr. Johnson's case. This is a type of crime that indicates a very high risk to the community. And so for that reason, for those reasons, the state's requesting $50,000 bail, DAS, no contact with minors.
Mr. Cruz?
Your Honor, he scores a 5. 4 of those points were all for his personal information. Course indulgence. I'd asked to set this over for one day. I'm sorry, we did not get.
That's okay.
We'll
see. That's right. Robinson should be our last case.
Go ahead.
Have a seat. Harness, back where you were.
What?
I think we've got a couple more, Your Honor.
Oh, all right.
Last.
Yeah, we're gonna trail Robinson to the end. I have Mr. Harness. I believe he has private counsel. Did they inform the court and ask to remove him today?
Ms. Clerk, I don't see that on our docket.
No, we have not received anything on Mr. Harness, and Judge, he's number 13 on the list.
I apologize. I do. And it's Mr. Johnson. Go ahead. Come back up, Mr. Harness.
Yes, sir.
And we just asked to continue this. Do you have any idea when your lawyer is available?
I have not been able to contact anyone, sir. Good morning, Your Honor.
Good morning.
Oh, okay.
So what do you want to do?
Court's indulgence, Your Honor.
Here we go. All right. So what do you want to do, sir? Mr.
We're gonna go. Oh, sorry. Go ahead.
Sir, I would like to continue. I would like to go ahead and process me today. Hopefully, I'll be able to get out on bail.
So have you hired Mr. Johnson?
Sir, yesterday when I was talking to the attorney here, he said that Mr. Obo was my attorney. I haven't been able to contact anyone, so I don't have any clue.
So according to what our record says, is yesterday you told Judge Birchie that you had retained Orrin Johnson.
That would be correct. I thought his name was Obo, so Orrin Johnson must be the attorney. But I don't know if he has any information that I'm here today.
So what have you done to retain him?
Sir, I've only been able to talk to my girlfriend one time since I've been here. So,
And you say that she has hired Orrin Johnson to represent you?
yes, sir.
The reason that's important, sir, is I can't talk to you about anything of substance on this case if you have hired an attorney. It's unethical for me to do so. And I know it's very frustrating that you are in jail and that your attorney's not here. And I hope you have the ability to first verify with your girlfriend that she's actually, because she may feel that she's done it and not actually done it, right? As far as retaining him. She may have made efforts or made phone calls or said she was going to do it. If she hasn't, then we can either have a conversation where you represent yourself. It's going to be difficult for you to obtain the services of the public defender if you've indicated you have the ability to hire an attorney. There's no free lunch, so to speak. I can't appoint you the public defender if you have the money to hire a private attorney. Go ahead, Mr. Cruz.
Your Honor, so what would ask is for another day to continue this. The sergeant here is going to allow him to use the phone to call his girlfriend. If possible, he can confirm that Mr. Johnson has been retained. If not, we can come back because I stopped talking to him when he told me he had private counsel. So if we can just trail this, and I'll just let you know if he can confirm he's got Mr. Johnson, then we can set it for tomorrow or Monday. If he doesn't have Mr. Johnson and the court,
He can apply certainly for the public defender. It may be that, again, his girlfriend just thinks that she was going to do that she has no idea how much it's actually going to cost.
Right.
Hasn't retained him. So there's a possibility that you could still get the public defender, sir, but not if you've got the money to hire Mr. Johnson, if that makes sense.
Sir, I believe we do have the attorney. I don't think that he has any idea that I'm here today.
Okay. We'll try and verify this so we can be clear and know better what to do tomorrow and what your rights and options are. Okay.
Thank you,
And
Your Honor.
thank you, Sergeant, for allowing you to make that phone call.
all right, thank you. And we'll just continue this then regardless of the law. Thank you.
Yes. All right. I know we have Robinson. Who else? We skipped over, it looks like Clarice Parker.
Yes. And he goes by Mr. Parker. I don't know why they have it hyphenated. Indicates he does not hyphenate his name.
All right. We'll just stay appropriate.
Your Honor, the state's requesting bail in the amount of $250,000, DAS supervision if he's able to post house arrest with GPS and no contact with minor children. I'd also request a prohibition from the use of the KIC website or application. So Mr. Parker scores a 3 on the risk assessment. He has no prior documented criminal history. However, most troubling, of course, are the facts of this case. The defendant began talking about sex with whom he believed was a 13-year-old child and continued to contact her on a yearly basis, 2023, 2024, and again, just this month. He quickly escalated the explicit nature of the text. He told her on more than one occasion that he has previous sexual experience with children her age. He asked multiple times to come see him at the GSR. He bribed her with a furry convention ticket, but in exchange, he told her she would have to stay with him all weekend. Importantly, he's under investigation for attempting to engage in sexual conduct with another 15-year-old child. He moderates a local furry group online, which he uses to find children. This is a person who pursues and preys on children. And so I think there is no amount of bail that this court could set there's no restrictions that this court could impose that would ensure the safety of the community. And so for those reasons, I am requesting $250,000 bail, DAS supervision, house arrest with GPS if he posts in no contact with minor children.
All right. Thank you, Mr. Poos.
Your Honor, this gentleman would actually score 0 if they were able to confirm his residence and his job. He has no criminal history. He's 62 years old. We were able to confirm his employment with the state of Nevada, able to confirm his address at 3114 Minony Lane in Carson City. We were able to do that through Transparency Nevada, as he works in the IT department for the state of Nevada. We were also able to find his name and his proof of residence through a Westlaw search that confirmed his address. Been there for years. I'd ask the court to consider a bail of $25,000, GPS monitoring, no access to the internet while part of his release, and no contact with minors.
All right. Thank you. The state's shown by clear and convincing evidence that there's no conditions the court can set to ensure the safety of the community and the appearance of the defendant. Therefore, the bail will be set as requested. As you're well aware, the conditions that the state asked for to prohibit the defendant from certain internet websites and engaging in this behavior, the court has no ability to enforce that, especially with the county abolishing DAS and the ability to do home visits to try and verify this information. So the bail will be as requested by the state because of the findings that I've made. We'll see the defendant back October 24th for arraignment on the criminal complaint unless we receive it sooner. Thank you. I think we have Hopkins, Newton, and Uribe. Are those the ones that are left?
Okay.
Ms. Clerk?
Yes, Judge.
All right. Hopkins, Newton, and Uribe.
Okay, court's indulgence. I think Hopkins, we're waiving. Let me double check.
And then going last, Judge, we have Robinson as well.
Right.
Your Honor, it looks like this is a PCS. He has a bail he can't afford on a failure to on $10,000 and a PMP will submit. I think it's a small amount of narcotics. I think it was found in association with his arrest on his warrant.
All right, what's the state feels appropriate?
Your Honor, the state's requesting $5,000 bail. It was 12.63 grams of meth that he had on his person when he checked in with PMP.
All right, and you're submitting, Mr. Foos?
Yes.
All right, that'll be the order. Newton, and then Uribe.
Yeah. Mr. Newton is waiving his appearance. I can go forward on the bail with this one. He does have a PMP hold.
All right. What's the state's position?
Thank you, Your Honor. The state's requesting $5,000 bail. I would request DAS with testing, but I understand where we're at with that. He scores a 10 on the risk assessment, 2 points for failures to appear, 1 point for felony gross misdemeanor convictions, 1 point for misdemeanor convictions. He's also got that PMP hold, as Mr. Foos noted. 2024, he's got felony arrest for probation violation, felony conviction for commercial burg. Looks like he's on parole for that. Misdemeanor conviction for petty larceny, misdemeanor arrest on other agency warrant, felony fugitive arrest, and misdemeanor resisting. Additional criminal history in Nevada, so very high risk of future non-appearance, continued criminal conduct. The state's requesting $5,000 bail.
We need to get his information.
Your Honor, the only real hiccup in this case is that he was apparently arrested back on the last Friday by PMP and then got ad booked a week later. So I don't understand why they waited. Just I'd ask the court to consider $1,000 bondable on the PD possession of drug paraphernalia. Again, he's not going anywhere.
Again, I think it's important to understand if we have individuals with controlled substance cases, are those individuals engaged in violent or felony theft related offenses? I think that poses a significant risk to the community. I think it changes the metrics from somebody who just simply continues to struggle with sobriety but does not put the community at risk. This individual clearly has in the past. Therefore, I must find by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant will be set as requested by the state, and we'll see the defendant back on the 24th, if not sooner, for the filing of the criminal complaint. Uribe and then Robinson.
Yeah. Your Honor, Mr. Uribe waived. Let me go back up and read my notes so I'm not saying anything that's.
So I can make this one easy on you, Mr. Foos. The state's not objecting to an OR on this case based on information received from the victim.
Fair enough. Thank you.
All right, OR, bail laws show up to court on, let's see, it'll be Monday, October 27th at 9 a.m. All right, that just leaves Robinson. So you indicated you're going to hire your own attorney. Have you done so?
No, sir.
What's your plan? You certainly have the ability to do so.
To interview a couple attorneys once I get out of here to see which one's best for my case.
All right. What does the state feel is appropriate?
Thank you, Your Honor. So Mr. Robinson is obviously differently situated than any of the defendants that we've seen on these similar cases this morning. He scores a 2 on the risk assessment with no prior documented criminal history. That's similar to some of the others that we've seen. The problem, of course, is that Mr. Robinson is well aware of what the laws are in the state of Nevada, and he's also must be well aware of really the implications of engaging in the illegal sex trade, especially with a minor. He knows what's behind that. We've usually got pimps that are being violent, that are taking money. So you're not just paying a child, you're paying a as well.
Sorry, I apologize for interrupting, because my intent was if the state was not asking for bail, then we could do this hearing today. But it sounds like the state is going to be asking for bail. Frankly, the defendant's going to be able to post whatever bail that you're asking for. However, he's certainly entitled to counsel to represent him if the state is going to be asking for bail, and you've been asking for significant bail, and I've awarded it in previous cases. And so what do you want to do, Mr. Robinson? You could represent yourself today in this bail hearing. The way it generally works, however, though, is you only get one shot. You don't get to do this bail hearing, then get an attorney and get a new bail hearing.
Oh.
We don't allow for that. You could represent yourself. I could canvass you briefly on your ability to represent yourself. I think you could do so probably adequately from what I know about you. But we could do that, and then we could go forward with this hearing, and then you'd have opportunity to, again, I think you'd probably be able to post whatever bail with a bail bondsman that is set. Doesn't mean it's right to go forward without your attorney. Doesn't mean it's right to have you represent yourself. But I understand the difficulty on a Saturday of trying to obtain counsel. So what do you want to do?
Well, I don't know if Mr. Foose also informed you I'm going through divorce, so I'm subject to a temporary financial restraining order, so my access to funds is limited.
What is your access to funds?
I have like $10,000 liquid right now that I can have access to. And even so, I'd have to reimburse the future X for any amount I take.
So, Mr. Foose, I'm not a criminal defense attorney. I never have been one. Do you think that's sufficient money to hire an attorney on this type of case? Do you have any ability to inform the court on that matter?
I don't. I would say that it would possibly, if he has a car or any other assets that are separate property, perhaps, whether through the divorce proceedings, they would allow him to access his quote unquote half of whatever assets he has to retain a lawyer. I don't know how that would work. I don't know if a lawyer would take the $10,000 in cash and worry about the rest down the road, or they'd take the case for just $10,000. That I can't tell you. I haven't. Yeah,
All right, I appreciate that.
A couple months.
Yeah, that's I was anticipating that. But Mr. Robbins, your salary has to be 200,000 with benefits or more per year, somewhere around there.
I'm retired, but I think that's what it's at right now currently. But I'll be losing a large portion of that to my ex.
Right. So I just can't. It'd make it much easier for me to just appoint the public defender and go forward with this today, but the law doesn't allow me to when you have the ability to hire an attorney. So do you want to represent yourself in this hearing this morning with regards to the bail, or do you want to continue it and wait to hire an attorney?
Can I have a moment with Mr. Foose to kind of get
He doesn't represent you. I mean, I like Mr. Foose too. I think he's a good guy. He's got good advice, but the county does not, the statute does not allow him to represent you unless you're indigent, or there's other extreme circumstances like you're incompetent, or other issues like that. And I just can't find that to be the case. So. Mr. Foose he doesn't work for me. He's free to do whatever he wants to do. I just can't sanction it. That's all.
Right. So what are my two options today? Represent myself
Yourself, or continue it to get an attorney to represent you.
Would the court allow me to be standby counsel if he represents himself? I don't want him to answer any questions that may be incriminating.
I certainly, yes, on that issue, and I'd advise him, and I would hope he understands the Fifth Amendment, and he's advised many defendants over the years with regards to it, that he should never talk about any of the facts of the case if he is going to represent himself, that this hearing is only about whether he's going to show up to court and whether or not he's a risk to re-engage in this type of criminal activity, and that he's watched, well, I guess he hasn't been present this morning, to watch the other hearings and to see what Mr. Foose argues and what the state argues. You've already kind of got a preview of the state's argument with regards to it. It's going to be that, there's no ability to prohibit you from engaging in this type of behavior because, I've had a case where the U.S. Marshals went in and put software on the router to make sure the person couldn't access these types of websites. Now, with the county doing away with DAS, there'll be no ability for me to have DAS go in and do that. So I can't even, do that level. But even in that case, when the marshals did it, the individual was able to obtain a cell phone, get on the internet, and solicit minors for sex. So it's difficult to effectively monitor individuals from engaging in this behavior. Now, from the facts of this case, yours, was not a 13-year-old or 14-year-old, as I've heard. I don't know everything that the state knows. But you are situated a little differently in that regard, and then your financial ability. So if you do go forward, that's what the hearing's going to be about.
Okay. I
And
proceed with the bail hearing.
okay, all right, then Ms. Phelps, please continue.
Thank you, Your Honor. So as I was saying, Mr. Robinson is situated differently from the other defendants we've seen today on these similar cases because he has a very intimate knowledge of what this dark underworld is like, what it involves for these young women, how they're brought into the system and how they're kept in the system and by a dynamic of power and control. I just can't overemphasize the level of danger that this type of crime presents to the community, because if there are no buyers, there are no pimps, and we don't have child sex trafficking. And he knows this. And he also demonstrated his knowledge, his intimate knowledge of how this underworld works when you look at the way he communicated with the undercover detective posing as the child. He used lingo that's very specific that only someone who has this intimate knowledge would know to use. Whether he's got that knowledge from his previous employment or whether he's got that knowledge from prior contact personally with this underworld, we don't know. We might have more answers for that if and when law enforcement obtains a search warrant for his electronic devices. But suffice it to say, Your Honor, really the argument here is that there's a risk to community safety, and also he knows that this is illegal conduct, that this is felony conduct. He took the risk, he did it anyway. And so for those reasons, the state is requesting bail in the amount of $30,000. I would request DAS supervision. I understand the court's position on that, but I would request no contact with minors. And Your Honor, just for the record as well, I would ask for that $30,000 to be bondable only based on the charges.
And Judge, we did reach out to confirm. I don't know if the court wants me to inform the court, but he would actually be a 0 on the NPRA. We were able to confirm his address.
I agree with that.
Okay. So we contacted his father. He confirmed the address. I'm sure the state can look that up anyway. They'll probably know it anyway. With that, I will have Mr. Robinson address court.
Robinson, what do you want to say, if anything? And again, you don't have to say anything, but you have the right to.
10% option.
And you're likely to be able to post that bail very quickly, I imagine.
If I was able to use the 10% option, I could.
Yeah, I mean, you could put it on a credit card, I assume.
Yes, Your Honor.
We accept credit cards. The ABA and all the best practices are that we offer a cash option of 10%. That's in my administrative order as well.
Okay.
And I no longer see a reason to deviate from that practice. So the bail will be as requested with the 10% option that is the best practice, and with conditions as set by or as requested by the state. And then your next court date will be an out of custody arraignment date for the 27th of October at 9 a.m.
So, Your Honor, just to be clear on the conditions, I asked for DAS. I know the court's.
I'm going to do it, and for
Okay.
as long as there's employees there. I don't know how long that's going to be. And look, for everyone that's here, I am hopeful. I remain hopeful that the DAS officers will be transferred to the sheriff's office, and that we will have a high-risk pretrial unit that can monitor these individuals, that the 24/7 program will go to the sheriff's office, and that they will continue it. And I've had great conversations with their leadership but as of now, I'm being told that all of the pretrial supervision, there'll be no caseworkers that'll go along with those officers to the sheriff's office, that all the caseworkers will go to pretrial services, and that the pretrial supervision, our only option for Reno Justice Court judges will be to have pretrial services at the district court. And my administrative order details the problems that we've had in the past with that relationship, and the significant concerns that our bench has in that regard. And we've not been presented any data or evidence to alleviate those concerns. And so I remain hopeful. I'm advocating for these tools to continue to be available to us. But the plan that I saw Thursday night provides, simply moves all the staff over to the district court pretrial services, and does not address 24/7 or high-risk individuals, and unfortunately doesn't sufficiently address the opioid intervention program of STAR as well. But we're working to try and make that happen as well, because that's a great life-saving program that we have. And so I have to make each decision individually today on what's presented to me as options, and that's all that's presented to me. I am working very diligently to get those other options back so that we can get these people released in the community, and or if they are released, protect the community, and ensure their success. But right now, our concerns have not been adequately addressed by the county at all.
Thank you.
Thank you. We'll see again, the other Miss Eddie or Edie again, to see if we can reduce her and some of these other folks tomorrow. And Mr. Robinson, we'll see you in a couple of weeks at your out of custody arraignment. Thank you.
And Judge, I had a question about that. Since bail was set, are we not setting the 72?
So bail was set. So he's out of custody arraignment date. We're not setting the 72. He'll be out of custody. So there's no reason for a 72-hour filing of the criminal complaint. So he'll be set for an out of custody arraignment date on October 27th at 9 a.m.
Okay, thank you, Judge.
You're welcome. Thank you, everybody. Have a great weekend.
You too, Judge. Thanks.